the OSP is making the PPA CEO scandal a foolish case, you will understand why I'm being openly critical of that office. How is the OSP making this case a foolish case, Manasseh?
Well, this documentary was first aired on this show in 2019, and 2 days after the documentary was aired, President Akufo-Addo suspended the PPA CEO and then referred the matter to Shraj and OSP for further investigation and possible prosecution.
Sure.
Shraj completed its report in 2020, and the president dismissed the CEO of the PPA, Ejinim Boatin Eje. The OSP investigation stalled because at the time, Martin Amidu, who was a special prosecutor, alleged that his investigators had been approached and compromised. And he even said in a press release that his investigators had told some auditors from the audit service who were helping them track the funds in ABAJ's account that, look, this is a case they could benefit from. Then Kissie Jabe came, and the case eventually went to court in 2022, June. In November, I was approached, and then by December, I was in the witness box. I testified, and I was cross-examined by 2 sets of lawyers. One set for ABAJ, another for his brother-in-law. So from 2022 December to 2024 April, I finished my cross-examination. According to the OSP's prosecutors, my cross-examination went very well, and that the defense lawyers could not puncture my testimony.
Okay.
At the time I was leaving the court, I was told that the next person to be called to testify for the OSP would be the Shraj investigator, because Shraj had also transferred his report and also documents to the OSP. So the investigator who worked on that was supposed to testify. Then, shortly after that, the OSP dropped the charges against ABAJ and his brother and filed what we were told at the time to be fresh charges against ABAJ. And what this means is that all the trial that has happened within the 2 years that the case was in court would be in vain. So we're going to start everything afresh. That starting point came in October this year when I received a letter from the OSP notifying me of the next court date. That's on the 20th of October. So that I should come and then start the cross-examination again, testify and be cross-examined again. Having spent a year and a half in the dock, I wanted to have a good reason to subject myself to all the time I had spent in court, all the resources driving in and out. I bore them alone. And if you've ever sat in the dock to be cross-examined by lawyers, you know that it's not a comfortable thing to do. They will try everything to annoy you, do anything to just destabilize you. So I wanted answers. So I called for the old charge sheet and the new charge sheet. When they gave it to me and I went through, I realized that all the charges in the so-called fresh charge sheet were contained in the old charge sheet. There wasn't a single new charge. Not even the particulars of the offense changed. Only some charges against ABAJ were dropped, and then the one charge against his brother-in-law was dropped. So the question is, why did they not amend the charge sheets if they wanted to drop some of them? I spoke to the director of prosecution at the OSP, and he said new investigation revealed new facts and evidence that was substantive enough for them to want to discontinue the case. So I asked the nature of that evidence, And he said he didn't have the docket before him, so I should speak to the lawyer handling the case. But he mentioned that it was new recoveries, financial recoveries. So I asked how much, because I know how much was uncovered during Martin Amidu's time. When I spoke to the lawyer handling the case, she said no new funds were uncovered. Did you trace ABAJ's assets as you've done in other cases? She said no. An attempt was made to do that, but it was abandoned because that wasn't the focus of the case. And I experienced within the period that there wasn't so much seriousness in prosecuting the case. For instance, the contracts for sale documentary was admitted by the court in evidence. And the OSP was supposed to submit a pen drive because they had asked for the documentary and the raw recordings, interviews I did. When they submitted that pen drive to the court, the documentary was not in it. So it was uncovered or discovered much later in the case. And they filed again to get a court to admit it. Of course, ABAJ's lawyers opposed it, but the court ruled in favor of the OSP, admitted the documentary, and I was called back. I had finished my cross-examination, but I was called back to be cross-examined on that. And after that, they discontinued the case. When they refiled again, there was a strong charge that was missing. If you read the Shrad report, you would find out that they said at a point, ABAJ altered the PPA board's decision to have a contract awarded in favor of a company, and that company turned out to be his company. In the old charge sheet, this was on count 18, under directly and indirectly influencing the procurement process. In the new charge sheet, this direct influence was dropped, and the charges in those sections now read indirectly influencing the procurement process. Meaning the whoever dropped the charge perhaps knew what they were doing, because you have directly and indirectly influencing the procurement process. Now, the charge which contains the direct influence has been dropped, and the section of those offenses or charges now read indirectly influencing the procurement charge. The other concern I had was that if you read the OSP's case against Mustafa Hamid, he's charged with money laundering because some money was found in his account that did not match his earnings. In ABAJ's case, 4 times of that money was found in his account. But in the first case that went to court and the second one, there isn't any mention of those funds in his account in the charges. So when I didn't get the responses I needed, I took the director of prosecution's email address. I wanted to send him an official communication that I am no longer interested in testifying in this case again, because I had done that. You dropped the charges without any tangible reasons. You filed again, there's no single new charge or particulars of offense. Rather, a strong charge has been dropped. There's nothing you've done about the money. You haven't traced the assets and all. Then someone suggested that I will speak to Kisi first. So I called Kisi Jabi on the 27th of October this year and said, I have concerns with the case you people dropped and refiled. So those concerns have not been adequately addressed, and I don't think I want to subject myself to another cross-examination and testimony. And he said I should give him 2 weeks and that he would look into the case and get back to me with responses. After the 2 weeks, he got back to me, but he didn't have the answers. He said he still had not gotten the answers, so I should give him more time.
Okay.
A month later, we spoke again. A month after I first reached out to him, we spoke again. And I mentioned the case because I was supposed to have started my testimony in October 2025. Then he said he still didn't have the answer. So I asked specifically, can you give me any timeline that you come back to me with these responses? And he said he could not give timelines and that he had ordered fresh investigation into the matter. And he did not mind that if those investigations were completed, the case would be dropped and they would file again. Remember, this is a 2019 case.
Manasseh, please hold on. He said he had ordered fresh investigations.
Yes.
Are these investigations different from the one that led to the dropping of charges, as in the second filing, or is based on the second filing?
The second filing, my sources within the OSP say there wasn't any fresh investigation.
Okay.
The only thing that happened was they called some of the banks to authenticate the payments that went into ABAJ's account, but there wasn't any fresh filings. There wasn't any fresh investigation, because if you look at the charge sheet, the offenses and the particulars of offense, everything remained as those charges were in the old one.
So if I get you,
So
if I get you clearly, what he's saying is that they are conducting fresh investigations, and the cases that the new case that has been filed could even be dropped for another one to be filed.
Yes.
Okay.
And if this happens, it will be the third time this case will be dropped and filed. We are entering 2026. This case started in 2019. And it is very likely that Kisi Ejabin would complete his 7-year tenure as the the special prosecutor, without ABAJ even being called to open his defense. And when somebody wrote about this case, Sami Dakun went, once Samuel Faran Otu on Facebook, just last week on the 2nd of December, Sami Dakun responded, and I'm just reading part of his response to you. In the second paragraph, he begins that, in fact, it is a fact that since the investigative journalist published his work, the office of late, and this is one of them, you cannot say trial is now beginning in 2025 December, when as far back as 2022 December, you called me to come and then testify. I was cross-examined all the way to 2024 April. Then he goes on to say something very interesting. Let me repeat. Investigative journalists provide a spark. What they uncover is not in itself evidence. Criminal investigators must scrutinize the material, build on it, corroborate it, obtain original documents, and ultimately convert information into admissible evidence. Then the very next paragraph, he says that investigators had initially relied on the journalist's findings to proceed to court, but once the case was reviewed, it was found to be hollow and lacking strong evidentiary support. It was therefore reinvestigated with parallel financial inquiries and authentications of documents to address the deficiencies identified by the prosecutor. So this is someone who is not just the director of communications, but he's also a lawyer, saying in one paragraph that what journalists do is not enough to ever take to court. Then he proceeds to the next and says, well, this is what we did. We went to court based on this, and after spending the resources of the state and people like me coming to witness for 2 years, you now identify the case to be hollow. You claim you did an investigation, filed again, and I came to you with answers even after you claim to have corrected your
about the fresh investigations, and whether you've spoken to the SP again after he told you he didn't mind conducting fresh investigations. And we've been speaking to Manasseh on what he knows about the contract for sale case against A.B. Ajay, former CEO of the Public Procurement Authority. The conversation with Manasseh. And Manasseh, before the break, you were telling us that the SP, you spoke and the SP told you that he didn't mind he had ordered fresh investigations and didn't mind dropping current charges and filing new charges. Since that conversation, have you spoken to the SP again?
No, I think this was 2 weeks ago. We have not yet spoken, but I got from that conversation was that, look, I cannot give you timelines when this investigation will be done, and that if it is done, you would know. What that also means is that because I did not agree to testify until I got satisfactory answers, the investigator from Shraj was called to testify. And what that means is that if they drop the charges, his testimony will also be in vain. So if they have to start the case all over, it will be whether I will be prepared to go and testify again, and whether the Shraj person who has been cross-examined already would want to go and start again. So there are so many implications for this case, and that is why I think eventually it is becoming a foolish case. Because if your key witnesses are frustrated to the extent that they are not willing to subject themselves to this process again, the evidence they are supposed to tender in doesn't go. And from the way they are even handling this from their side, I don't know what else they are coming up with. So there are so many implications for this case, and everything looks to this case possibly becoming a foolish case, not because the courts have frustrated it. The special prosecutor had held a press conference to accuse the judiciary of some kind of hostility towards the office. But in this case that I witnessed, there was no such thing. Almost all the objections raised by the defense lawyers were overruled. All the evidence that I submitted was accepted. And if you look at everything that has happened, the judiciary has done its part. President Akufo-Addo acted excellently on this case. But everything that is making this case a foolish case is coming from the office of the special prosecutor. And mind you, this case is not as complicated as the SML and other cases. So the question is, if the office is messing up with this case this way, what kind of trust would people have in its handling of the other cases?
But Manasseh, somebody would argue that you need to take a good case to court, and you've heard current Attorney General Dr. Dominic Ayine make the point that if he's not sure of securing a conviction, he wouldn't go to court. So maybe, just maybe, they're trying to make sure that they secure a conviction, isn't it?
Yes. So when they first went to court in 2022, nobody held a gun to their head to take the case to court. They had not completed an investigation and come to a position that they knew they could secure a conviction. Again, when they dropped the charges and filed again in 2024, they did not do that under duress. They said they were convinced that they had the loopholes and everything. To 2025, if you look at their budget, expenditure and everything, their reports, this single case appears. So if it happens that you're supposed to do something and you don't do it, and you are spending money on the same case every year, and as we stand from 2019 to 2025, we are ending 2025, the case hasn't gone anywhere. So the question is, how many more years are we going to spend on this case? And how many more years are we going to allow a state institution that is supposed to safeguard the public funds to keep spending on this? And I've raised concerns about SML and then this case. These are cases that I'm personally involved and I know the details, so I can challenge them. The question is, what else may they be doing in the other cases that maybe some people don't have their eyes on, or perhaps for the fear of being accused of attacking an anti-corruption institution, they may not be bold enough to speak up the way I'm speaking up.
The question of what else they may be doing suggests to me that you don't trust this office. Is that the case?
I recently had cause to disagree publicly. Said, for instance, this office had created an impression that Ken Ofori-Atta left because they did not get cooperation from the state institution, so they watched him leave and they were helpless. I decided to do an independent probe, and it emerged that in the old and this new administration, none went on the 5th of February 2025 from the Office of the Special Prosecutor. They have not denied that. And I also secured a diary of action taken on the SML case. And then on the 30th of January, the first entry into that diary was the 29th of January. On the 30th, a supervisor or superior wrote that please proceed with the preliminary investigation needs and prepare an investigation plan and identify the persons of interest we will need to interview and appropriate departments and agencies to provide information. This was entered on the 30th of January 2025. So you cannot claim to have started an investigation in 2023. And in 2025, you are saying that let's proceed with preliminary investigation. Let's prepare an investigation plan. Let's identify persons of interest and institutions that should give us information in this investigation. And Sameh Darko had said in response to my earlier publication that when Ernest Akore, the man charged together with Ken Ofori-Atta, was leaving Ghana, they did not know he was a person of interest. And he left almost a year after they received the petition. So I had cause to doubt them. They claimed they had saved $2.7 billion as a result of the SML investigation. The facts of the matter is that the entire contract sum was about $500 million. Nothing close to $2.7 billion.
Okay.
By the time the special prosecutor finished its investigation, 2 of the contracts were cancelled. 2 had been suspended. The only payments that were being made to SML at the time was $1.6 million a year for the downstream sector contract. And 2 years had already passed. So even if we were to take the $500 million that was saved, OSP's contribution is very minimal. 2, there was no $2.7 billion anywhere. Kisia Jabe told me that that figure came from a PPA report. And then when a PPA approval letter, when I published the letter, there was nothing of that sort. And they have now gone back to the same figure I said, the 500 million. So if you put all of this together and then what we are seeing, whatever comes from that office, I will be more critical about it than I was before.
Manasseh Azuri Awene, thank you very, very much for joining us this morning.
Thanks for having me.
Great, and that's Manasseh Azuri Awene joining us.